even something as serious as a murder conspiracy. So the government had this information at the time, and I remind you also that the leader of Information Services, Mr. David Vigneault, had supported the government's decision. I remind you that the House of Commons had voted to ratify the decision to call the Emergencies Act, and I remember still that the Government of Ontario also supported the Cabinet decision. As my colleague said, the judicial system provides for appeal, and we'll use it because we don't agree, but I think it's important to consider the context of national and public security that existed at the time when the decision was made.
I think it's important to remember the context almost 2 years ago today, those weeks in late January and February 2 years ago, the public safety and the national security context. I was in Ottawa during those weeks, as were my colleagues. I participated in the cabinet discussions. We were updated by senior officials about the risks of copycat incidents at other border crossings. I spoke to premiers from British Columbia to Nova Scotia about risks to their community safety. We saw border crossings and the damage to the Canadian economy, thousands of jobs put at risk. We spoke with the Premier of Ontario and the Government of Ontario that supported the invocation of the Emergencies Act 2 years ago. I think that's an important moment. I think it's also important to consider the government was given information with respect to the disruption at the border crossing in Coutts, Alberta. It's not banal when the security services tell you that they found 2 pipe bombs and 36,000 rounds of munition and ended up laying criminal charges as serious as conspiracy to commit murder and assaulting peace officers. So the context is important. I think it's also important to note that the House of Commons ratified the decision to invoke. But as my colleague said, the judicial system also includes appeal mechanisms, and the government's made that decision. But I certainly, as a minister who participated in those discussions and who spoke to premiers across the country, am very satisfied that we made a reasonable decision and will now let the appeal courts consider the filings from my colleagues.
If I could just add one thing in terms of the judicial decision that was rendered today, we also know that a member of the Court of Appeal, Justice Rouleau, conducted a very public, comprehensive and transparent investigation into the reasonableness of the government's decision. That decision stands at odds with the decision that was rendered today. I think that is important, and that also informs our decision and our basis upon which we will proceed to an appeal. Donc, j'aimerais juste le répéter en français. Donc,
just like to say this in French.
Il faut souligner aussi que
we should also underscore that the appeals judgment of Ontario, Judge Rouleau, made a transparent and comprehensive decision regarding the Government of Canada's decision. He had concluded that his conclusion was different from the one received from the federal court today, so that informs our decision to proceed to an appeal.
The decision seems to single out some of your choices on freezing bank accounts and credit cards as being part of the reason where it's unreasonable in terms of the measures taken by the government. You defended those when you announced them at the time. Do you have any regrets on taking that measure in the light of this decision? Would you have done it differently based on what we've seen from the federal court today?
As I said in my opening remarks, we faced, as a country and as a government, an incredibly serious threat. A threat to the public safety of many Canadians, a threat to our national security, including our national economic security. We acted to secure and protect Canada and to secure and protect the national interest. It was not an easy time. These were not easy decisions. In making our decisions and choosing to act, we worked very, very hard with all levels of government, and we were very mindful of acting in such a way that the safety, the physical safety of all Canadians involved would be preserved. I don't want to minimize the gravity of the actions we took. Neither do I want to minimize the gravity of the threat Canada faced. And to your question,
all right, we are following some breaking news from Ottawa this hour. A federal judge has ruled that the Liberal government's use of the Emergencies Act to clear Convoy protesters back in 2022 was unreasonable. We just heard from the federal public safety minister and Deputy Prime Minister Chrystia Freeland reacting to this. They say the government does not agree with this decision and it will appeal it.